In this video, we are going to talk about family law and family law appeals. My name is John Flood. I'm a divorce and child custody attorney with a principal office in Houston, Texas.
Hi there. Good to see you, John. And I'm Kyle Carney. My principal office is in Fort Worth. I handle primarily business and employment law disputes, but I also do appeals, and that has some crossover with family law. So, John and I thought it would be a good idea to talk to one another about our practices in some of those crossover areas.
And we're going to do this in a question and answer format. So I'm going to ask Kyle some questions, and Kyle's going to ask me some questions, and we'll just roll it out like that. Kyle, do you want to go ahead?
Yeah, sure. And thanks for the opportunity to kind of jump on video with you. I've
Yeah.
really enjoyed watching some of your videos, and I've learned a lot, frankly, about some family law. So if anybody's watching, they should head over to your Facebook or one of those other media platforms where you're sharing your videos. They're uh, super informative. Um, as you know, we practiced together a little bit when you were a civil litigator for a brief time, and I'm frankly just I want to I'm a little bit curious to know when you started your own practice and focused in on family law, what are some of those things that you took from your time in both civil litigation and past family law experience? How did you blend those together? What lessons did you learn that help you in your practice today?
Yeah, so I think there are some there are, of course, some ways that general civil litigation, non-family law litigation, and family law litigation are similar. There are a lot of similarities there. As you know, they're both governed by the Texas Rules of Civil Procedure. They're both governed by the Texas Rules of Evidence and that sort of thing. And then there are some differences. And I think in my time practicing in civil litigation more broadly, one of the things that it developed in me that I think was maybe lacking before was you do more discovery in a typical civil litigation case, non-family law. You tend to do a lot more in the way of discovery than you do in family law. A lot of family law cases, there's little, and in some cases, no discovery at all done. And so I think that was one of the things uh, that I developed, one of the skills that I developed more so as a civil litigator, non-family law civil litigator, was spending more time in discovery. And then I think there's also more overall. Uh, you spend more time in the Texas Rules of Civil Procedure, I think, in non-family law civil cases, and so it helped me become more familiar with the Texas Rules of Civil Procedure, and of course, I brought that into family law. I think with family law cases, there are some things um, that we're doing that you don't do as much in non-family law cases. For one thing, you're in court a lot more. In family law cases, you're just in court a lot more. And that was one of the things that surprised me when I was doing non-family law civil litigation is just how infrequently really you go to court. You're just not in court very often, and most cases settle outside of court. Whereas in family law cases, it's much more common to have a contested evidentiary hearing somewhere along the way, whether a temporary orders hearing or a final trial. It's much more common to end up in court. And then along with that, it sharpens your understanding of the Texas rules of evidence because when you go to court and you have a contested evidentiary hearing, you've got to make sure that you stay up on the rules of evidence and that you're able to use those in court. And you don't get as much experience with that outside of family law.
There's a few things I want to touch on, and I want to just I'll try to take them in the order that you presented them. But in discovery, um, when you mentioned that, how do you take an approach to discovery now in a family law case? Does that lead you to sending subpoenas to third parties, or are you pressing on opposing counsel more? Can you speak a little bit about what you're doing there?
Yeah, so I think in family law, because you're dealing with an individual and individuals are paying the bill, I think there's more discussion than you'll see in, for example, with commercial litigation where you're dealing with businesses that have more money. There's more discussion around whether you should conduct discovery. And if so, the scope of discovery and how far you want to go with it. Because, as you know, discovery can be time consuming, drafting the request, sending the request, getting the documents, organizing, cataloging, reviewing those documents, and then pushing forward if you need to with the motion to compel all of that. So when you have someone who has limited funds, maybe coming out of a 401k to pay their attorneys, fees or a savings account or something, you have to have conversations with the client in family law cases about, does discovery make sense? Are there documents that we need to pursue? And if so, what are those? So I think that's the first thing I would say is that in family law cases, there's more deliberation and intention around discovery and whether you're going to do it, and if so, the scope of it. But it is very important, if I've got a client and it looks like we're going to go to trial, I really will push on them to pursue discovery, and to pursue that as far as we need to go. And it's not uncommon to have to file a motion to compel to get documents, an opposing party, and to have to lean on opposing counsel and opposing party to get what you need. Because sometimes, for example, text messages are vital. I've won cases. I've flipped custody on text messages, and I had to, and because the text messages had damning information in them, information that this party did not want to give up. And so I had to file a motion to compel and pursue those and get those, and that ultimately ended up winning the case at the end of the day. So I would say with a family law case, you take it case by case in terms of what you're going to do in discovery, how much money your client has to spend. But when you've got a client that wants to pursue it in a case where it needs to be done, you put the gas you put the gas down to the floor, and you get what you need to give you the best chance to be successful at trial.
When I deal with a little bit of that with my small business cases. I represent a range of businesses in disputes, or sometimes, you know, partners who are breaking up, and we sometimes refer to them as business divorces. In some cases, those are real divorces that are connected to a business, but I'm usually working with somebody like you, handling the family law side of that. Um, but you mentioned if the budget is tight, you just got to be ready to go. And so, can you speak to how did that, I guess, um, sharpen your skills? Can you think of a time where you had to show up in court and cross somebody without any documents? I mean, I've had to, I can probably count on my hand the times that I've had to do that without any discovery, and usually it's at a TRO hearing. But can you speak to how you had to develop those skills and how you use those for your clients?
Yeah, that's a good question. So that is actually kind of common in family law because it's not uncommon to have a temporary orders hearing pretty early in the case. A lot of times before you've had a chance to get discovery back or get a full response back on all your discovery requests. And so it's not uncommon to have a TRO hearing, a temporary restraining order, or a temporary orders hearing, and to be working in that hearing off of no discovery. And I've also dealt with that in CPS cases when I've represented, I've been an attorney ad litem for children appointed by the court, and it's a child protective services case. And oftentimes in those cases, an attorney ad litem will not send discovery. You're being paid by the court or by the county, so you kind of keep your fees down and things like that. And you work off of little to no discovery in those cases as well. And I'll tell you one thing it has done for sure is it has forced me to get better at how to get what I need out of a witness without any documentation backup. And so you learn it does force you to get better at direct and cross and learning how to box people in or find ways to try to get the truth out of them without having a document to say, here you go, you're lying, or impeach them with a document or something. Not having that does force you to be more creative. And I think one of the things it's made me do is script. I script my direct and cross examinations frequently, especially in hearings when I don't have document backup, because I need to think about beforehand, how am I going to entangle them, or what kind of questions am I going to ask that are going to make it very difficult for them to lie, or for them not to give the kind of answers that I want or that I need to get the evidence out. So I think it helps with that, and definitely in family law, I think you do see that a lot more now. Ideally, when you get to trial, by that point, you've got your documents, and that's not an issue. But a lot of temporary orders hearings are quick and dirty. You don't, you don't have a whole lot of time to prepare. You don't have months to prepare. You don't have documents, and you have to go in there and you lean on your client a lot more in those cases. You have to be able to extract more information and what documents you can from out of your client, to prepare for a hearing like that.
Yeah, I'm frequently impressed by you and other family law lawyers and what you can do with a witness with no documents. If I'm going, what is this person gonna say? That that's just the kind
Yeah,
of the proverbial don't ask a question you don't know the answer
I
to,
know.
but you
Yeah.
frequently have to do that.
That is so true because you also don't do very many depositions in family law cases. So you're questioning a witness, sometimes even at trial, for the first time. You've never questioned them in a deposition or in any previous setting. Sometimes temporary orders hearings can be good like that. It's almost, it's a crack at the witness and almost a substitute deposition. But yeah, you're absolutely right. I always think about that. That's the other balancing act is, you know, you don't normally want to ask questions if you don't know what they're going to say, or if you know they're going to lie and the lie is going to be favorable to them, and you have no way of getting to the truth because your other witnesses may lack personal knowledge. So I see this a lot in custody cases where I represent a party who hasn't been inside their house for years, and you don't have anyone who's been inside the other parent's house, can't really testify to what's been going on in the house. The children's statements are hearsay. And so you can really get kind of boxed in, and it can put you in a difficult position sometimes in that regard.
The other thing you mentioned is kind of the differences um, and similarities in procedure versus the family code. I do some family law appeals, and so I sometimes find myself coming in either to assist a family law lawyer with an appeal or taking kind of a difficult case from a procedural angle up on appeal. And I've one of the things that I find fascinating about family law is kind of the temporary orders pr proceedings that you were referencing at the beginning of the case, because practically it is an injunction that's being ordered in the case to order parties to stop doing something throughout a case or to do something throughout a case. And the family code obviously has special provision for that. Um, to me, the family law cases I've seen can sometimes feel like the Wild West in the way that judges will just exercise a lot more power than maybe a civil district court judge would. Not that the civil district court judges won't exercise power if they have to, but I just see that uh, it seems to me the differences that I've observed is that civil district judges are usually a little bit more reserved in the way they exercise their power or make sure that, the I's are dotted, T's are crossed in following injunction procedures, whereas In a family law case, it's fast and everybody's just going, let's just make sure the kids are safe. Boom, order. Everybody agree to this. Sign it now. Kind of thing.
Yeah.
Feels like
Yeah.
people,
Yeah.
has their have their can be a little bit more um coerced. I don't know if that's the right word to use, but there is more
Yeah.
coercion involved. So, uh,
Yeah.
can one of the challenges that I've looked at on appeals are the notice proceedings. I've seen family law judges enter an order without really completing the temporary orders hearing, never really entering findings, but still putting parties under orders. And I've toyed with challenging that before. Can you speak to some of those issues and how do you help parties navigate that uh, complex temporary order proceeding at the beginning of a case?
Yeah. Those are some good insights in terms of how what family law temporary orders hearings are like. It's definitely very difficult. And to add to all the difficulty, courts give you a very limited amount of time for a temporary orders hearing. Uh, at best, most of the time, you're not going to get more than 3 hours in total. That's an hour and a half per side. Sometimes it's even less than that. They'll give you 2 hours, so an hour per side. Or sometimes I've even had 45 minutes per side. So you are very limited in the amount of time that you get, and that makes it even more difficult. And so you're dealing with all sorts of constraints, and yet at the end of the hearing, as you note, a court's going to make orders regarding conservatorship of children, possession and access of children, child support, health and dental insurance, who's going to have temporary use and possession, exclusive use and possession of a marital residence. These kind of actually big decisions, and this order could be in place for as much as 6 months, 9 months, 12 months, and put that party who gets the favorable ruling in the driver's seat going into trial. So it's a really, I don't think most clients, I try to explain this to clients the best that I can, all the constraints that I'm under, that we're under, really, in a temporary order setting, but it's very difficult, I think, for them to fully comprehend that. Um, and the short answer is you do the best you can. And you really do, as I talked about earlier, you really lean on your client a lot when in the temporary orders context. You really have to work closely with them to get as much of the facts as you can, to get a solid chronology, to get as many documents as they can get their hands on, and to prep them to testify at a temporary orders hearing. Now, the thing you have going for you is the other side is under the same sort of constraints that you are. So they have to deal with the same thing. And I think one of the ways that I've been able to be successful in the temporary orders setting is by just out preparing the other attorney. Um, Working with my client so closely that in a 45-minute setting where we've got 45 minutes and most of that is going to be with my client, really developing their direct a lot and preparing them for cross, and then preparing a solid cross examination of the opposing party, because it's not uncommon for that to be all you have time for. You have time for your client to be a witness, and for the opposing party to be a witness, and for you to cross examination or to cross examine them, and not much more. And so I think one thing that I've learned is the importance of working with your client to be uh, closely, to be successful, and make sure that y'all are as prepared as you can be. And not all attorneys do that because of the time constraints, and everyone's busy. A lot of attorneys walk into temporary orders hearings unprepared, in my opinion, unprepared. And that puts them at a major disadvantage. And so I try to make sure that I don't do that. And to your point, in a temporary order setting, judges have such uh, broad discretion. I mean, the legal standard is like safety and welfare of the children, best interest of the children. I mean, they can do just about whatever they want under that kind of legal standard, and there's not a whole lot you can do about it. And I'd be interested to know from, from your perspective as an appellate attorney, what sort of ways or what avenues have you looked at to deal with adverse temporary orders rulings? I know it's very limited. You're probably looking at mandamus. Have you what have conclusions have you come to, if any, when looking at trying to appeal those rulings?
I have attempted to, you're 100% right. It's broad discretion. You're pretty much limited to mandamus at that stage. And almost for, uh, I would say before we even discuss any of this, for any client listening to this, that 99% of clients don't need to even think about or consider mandamus actions. It's more than likely you've got to suck it up, deal with the order, get evidence that you're being a good parent, or if you've got some things to fix, you need fix them and come back and seek a modification later is almost always the best answer. But there are requirements that at least under while the family code empowers judges to make broad rulings, I've looked at challenging temporary orders by mandamus, holding those orders to the standards of the Texas Rules of Civil Procedure, because there still are requirements that the orders need to follow. And sometimes judges will string things out and strong arm parties while not exactly following those to the T. I've seen cases, I don't believe it's too infrequent, where maybe a temporary orders hearing doesn't quite wrap up. The testimony and evidence is not all done. To your point, they happen usually pretty fast, but if at the conclusion of the hearing, if the judge doesn't simply just cut everybody off and make a ruling based on the evidence and continues that, there may be a temporary order that is effectively like an injunction, but with no findings, that ends up governing the case for some indefinite amount of time. And there's a gray area there, um, where sometimes I think those are attackable. Um, that in the temporary orders context, that it can be useful to get appellate counsel to look at that and consider if it's worth it. To your point, it's going to be a real special case if it's worth it. And maybe doing that just gets you a little leverage to discuss with the other side. Maybe everybody just avoids going that route, and maybe the potential of a mandamus gets everybody to agree, or shifts the dynamics of the case. But it has been tried, not usually successfully, but it mandamus is available for that 1% of cases where it makes sense, and there's some gray area in the temporary order space.
So I want to ask you, kind of looking ahead now toward a trial. So, in what sort of cases do you think that a family law case or a family law attorney should consider bringing in an appellate attorney like yourself to help with the trial, or maybe to take a look at a court's ruling in a case? And what sort of cases does that make sense? And would you recommend, bringing in an appellate counsel to help with those sort of things?
A couple of thoughts would be, one at the begin the one I'll say one time at the beginning of the case, other than temporary orders, would be if you've got a spouse that you know is moving somewhere else. Then, and or if you have maybe adopted children involved, something like that, where special statutes control venue, and maybe there's jurisdictional arguments about what court you're filing into and where, and maybe you don't hire appellate counsel to totally come in and do an appeal, but you just maybe want a small team. You don't need a large overlawyered team, but some collaboration to look at the case and see what potential procedural angles are here that we need to either be careful and mindful of, or if we're challenging something, set up a potential procedural issue later on in the case. For example, um, venue can be challenged because if I remember right, you have to reside in the venue where the suit is filed for 6 months, and maybe if that sometimes for various life reasons might be in question as to what the proper venue is, and so maybe you get somebody in to collaborate on where to file, or if you think it was filed in the wrong place, how to challenge that initially. Another point later, maybe more for divorces where there is a business involved, then you might have a collaboration between lawyers to set up findings. If it's not going to be agreed later on, you're getting to trial. As you mentioned, you may want to do some discovery, bring in appellate counsel to say what issues might be here that we need to get objections ruled on, and set up potential appeal ahead of time. Those are all situations where a collaboration between a family law lawyer and an appellate lawyer make a lot of sense. And some you don't necessarily need to hire a big firm or hire, two lawyers for the entire case. You can just hire them for a specific purpose to come in and help once the rubber meets the road, and if it looks like the case really is going to be contested. You can always get appellate review right after trial, um, but you want to be careful about timing because a lot of times clients only come to an appellate lawyer after the time deadlines have passed to get findings of fact and conclusions of law, or things like that. Um, if you're going to challenge a judge's ruling, whenever there's really broad discretion, as you mentioned, if there's any hope of challenging that, a lot of times you want to request findings of fact and conclusions of law and at least request those. There's a deadline to follow up on requests for past due findings of fact and conclusions of law, and you just want to make sure you hit those post-judgment deadlines after a judgment has been entered. The other side will, if you're on the losing end, the other side's going to submit their proposed findings of fact and conclusions of law, and the judge is just going to sign those. But what that does um, for your family law clients is then that sticks that judge to that reasoning, and then the court reviewing up above isn't free to just come up with whatever reasoning might possibly support the judgment. So it at least narrows the scope of the fight down to a few reasons. And they're going to be really favorable to the other side, but you at least stand a better chance of attacking them if they're reduced down to, some number of written reasons why you lost the case. And then you might be able to get a court above to disagree with that, or find a procedural error that requires the case to go back. So,
Yeah, I've thought, ideally in an ideal world where you have a client who has the money to afford it, I've always thought it would be best to have an appellate attorney on your trial team to be there prepping with you during trial prep, and then also to be present at the trial to help you preserve error, to catch the proper objections, to make sure that those objections get ruled on, to make sure that your offers, proffers, and offers of proof and things, all of that get done properly. or bill of reviews, whatever you have to do in the course of the trial to preserve error for appeal to make sure that all of that gets done. That's an ideal world. So I think certainly, and along those lines, there are some differences in the way that attorneys and trial attorneys think, in the way that they approach cases and their expertise and experience. What in your experience, what are a few ways in which appellate attorneys um, differ or have some expanded expertise as compared to trial attorneys when we're looking at appeals and preserving error and things.
I think the differences usually just come down to where we gravitate in our focus. Usually, a good trial lawyer like yourself is just in the facts, and you're going to win the case on the facts. And as an appellate lawyer, I have to um, sometimes remind myself to do that because I'm a lot of times in a position where I'm either looking at a trying to correct an error below or a loss and making sure that I deal with bad facts and what's persuasive to an appellate court isn't always presenting your client's rosiest picture. So obviously, I want to tell a story that my client needs to tell, but what's persuasive to a judge is putting those bad facts in up on paper and saying it doesn't matter. You have this judgment is wrong anyway,
Mhm.
um, and explaining that from a legal perspective. So the my center of gravity in the way I look at a case tends to go towards the procedure, and towards the to see can I win on the law, even if it looks like, maybe my client should have or could have lost in some way. And I'm constantly gonna just be thinking, how can I use the law to my client's advantage and bring about another chance. That's not always the case that my client was the loser or should have lost. Sometimes uh, a judge or jury makes a bad decision. I was reviewing a case this last week where the other side said on the stand, I messed up that job and I wasn't ever going to charge for it. But that there were several jobs in dispute and uh, on this construction deal, and the jury awarded breach of contract to the other side and gave that side those damages, even though they admitted on the stand that they messed up one of those jobs and we're not going to charge
They
for it.
didn't
And you
hear
have to
that.
go,
The jury was asleep
yeah,
when
yeah, you
that
just go,
got said.
yeah, you go,
Yeah.
where did they come up with that? I mean, I could see them going for the other side on the other items. But you just sometimes judges or juries make decisions that make you just go, huh? And so that's
Yeah.
and so sometimes you're trying to wrestle with a difficult standard and trying to present that to a court. And so my focus differs a little bit from trial lawyering in that because I'm staring the bad facts in the face, and I have to deal with an appellate standard that gives deference, gives the jury or the trial judge the benefit of the doubt. So I have to say, um, I have to let my clients know I'm going to do my best to tell your story, but we still have to put these bad facts on paper and say, even so, the judgment is wrong. It has to go back.
Yeah.
And that's what I'm constantly having to do.
Yeah. Well, Kyle, it's been good talking to you. I think we're gonna wrap it up here. I really appreciate you taking time to join me today, and I think this has been a productive conversation.
I agree. I appreciate your time and really enjoyed catching up with you.
And do you want to maybe give your contact information for anybody watching?
Yeah, I appreciate that. If you're watching this video and you're interested in business employment or appellate cases, my contact information is kyle@carnegie.law. My website is really easy. It's my last name dot law, www.carnegie.law. And feel free to reach out, give me a shout. And you can also visit me on my LinkedIn page. And
My name is John. Oh, go ahead.
I
Sorry,
was
go
going
ahead.
to say, same for you, John. T Tell
Yeah.
everybody where to reach you.
Yeah, so I can be found at www.floodlaw, that's FLUD as in Delta, law.com. You can also reach me by telephone at 281-407-7876. I'm also on Facebook, Flood Law PLLC, and on LinkedIn as well. So you should be able to find me if you Google Flood Law. All right. Well, Mr. Carney, I appreciate it, sir.
Same.